welcome to Houston Real Estate Radio. I'm your host, Shannon Register, and every week we try to bring you information you can use. Anything that has to do with real estate, we feel like we've pretty much covered it over the last 4 years, and really like to just educate you on real estate and answer your real estate questions. If you've got a real estate question, you can give us a call at 844-788-9444, and we're happy to answer your real estate questions right here on the air every week, 844-788-9444. This segment, we're talking about something new and different. We've never talked about this before because it is something new. You may have heard about it. It's the Texas Transfer on Death Deed. It is something that the legislator put into effect in September of last year, and I hadn't heard of it and just started doing a little research into it, and this might be something that could be beneficial to you or someone you know. So we want to talk about it today. So we brought in an expert attorney to talk about it, Christopher Barber, attorney and counselor at law for the Houston Law Group. He does Texas estate planning. He's a Texas estate planning attorney. So welcome to the show.
Thanks for having me, Shannon. I appreciate it.
So this is an interesting thing that our legislators decided to put into effect to really to help people.
It really is. While the legislators are out there doing a lot of stuff, this one was really specifically targeted to try to help people that are a little bit of lesser means.
So the Texas Transfer on Death Deed, what does that mean?
It basically is a legal document you file with the county court that you can leave your property to somebody you designate in the deed.
Okay.
This eliminates the probate process or creating a trust or some other kind of planning.
So kind of like how you have a bank account and you put a beneficiary on the bank account, and then when you die, that money, they have access to that account and that money.
That's
it's kind of the
exactly
same
right.
thing, but you're doing that with your property.
It is. And they looked at those laws here in Texas and in other states to come up with this. They really put some thought into it to try to make it as straightforward to the quote-unquote average person of limited means as they could.
So what provoked this?
Actually, some of the background is from the hurricanes we've had recently, like Ike. To get some of the federal funding, that people needed to prove they own the property. Mm-hmm. And they would find out sometimes that they didn't. They didn't own it fully. So maybe dad died 10 years ago, and then mom had passed away 2 years ago, and nothing's been done. They're just living in the house.
They never probated a will.
Never probated the will, never even thought about it. If they even had a will. Mm-hmm. They still say 70% of the people do not have a will of any sort. Mm-hmm. Then it goes, hey, it's great. If you don't want a will, the state has one for you. It's either whether you go by the laws the state made or you go by the laws that you've decided to create by leaving a good estate plan in place. However, this is for the people that are really of lesser means. So they can do this straightforward document and get a kit online. You can go to my website if you want to get a copy of that to a link.
So let's give your website. What is your website?
It's estateplanninintexas.com.
Okay. So they can go to the website. They can get this whole kit with all the paperwork to complete.
Exactly.
Does it tell them how to file it, where to file it?
The instructions are extensive. It goes over almost everything you can think of. It's not just the deed, but also the affidavit the person has to file when the person passes. They'll file the county records, and that will transfer to their name.
So this might really be good for some people who are on a fixed income, that are elderly, that are trying to get things in order, but may not have the means to go to an attorney to get it set up.
That's exactly right. Now, of course, I'm biased. You can use an attorney.
You're an attorney.
I am. That's right. And estate planning can be like a parachute. You only need it once, but it better work.
Yeah. So this is interesting because this actually trumps a will.
Which
if
is
there
very
is a will
interesting.
in place.
Yes, and that can confuse some people. Mm-hmm. This takes priority. It really is for the person of limited means. Again, fixed income is a great example, that they don't have to mess with the probate process. Now, probate's not evil. Probate is a court proceeding,
It can be very intimidating, though, if you're not familiar with the law,
Exactly right.
not familiar with where to go, how to do it, what to do. Because I've sold houses for people who need to go through probate. The husband died and the wife's trying to sell the house, or vice versa, and they're intimidated to go down and go through that process.
Oh, yeah, and they got to deal with lawyers. Oh, my gosh, not that. However, we really do try to make it easy.
There's a cost associated with it.
And there is. But the fact is, it's like, I restored old cars. I built an airplane. I know how to do that. That is what I do. My mom couldn't do that. She'd have to go to a professional, and it's an overwhelming thought just thinking about it. The fact is, this gives something straightforward with clear instructions that can let the average person just do it themselves.
And you can do this when you purchase a home, your homestead.
Yes.
Or you can retroactively do it while you're living in your homestead.
Because you already own the property. You can't transfer what you don't own, but if you own it, you can transfer it and use it.
So even if you bought it 30 years ago, you can go and do this today.
There should be no reason not to. That's exactly what's going to be set up for. If you want to avoid the probate process for this piece of property and you don't lose your exemptions, you still get your homestead, that's specifically spelled out because they're not trying to confuse the process. They're trying to
simplify it.
Exactly, trying to keep it simple, right? That's what they always say. So that's what they're trying to do, and this really does do it. The kit that you can download gives these instructions, gives step-by-step, fill this in, let you know you can't use your description of the property from like your tax rolls. You need a complete legal description. That's probably the most confusing part of it, is to get that legal description right, which is imperative.
So for a person buying their homestead right now, today, they go to the title company and they close on it. Why are title companies not giving them this option?
You know, I don't know if they really know about it. You didn't know about it, and you're really versed in your area. But you found out, and I applaud your efforts for getting more informed about it. I don't know if they know about it. I don't know if they're afraid because it's new. That is always something interesting. It's like getting the first year of a car comes out. You might want the kinks to work out. Well, that's kind of the same way. There may be issues that we never thought of, but I don't think so. This seems like they really put in the time in Austin to figure this out right. I'm not always think that's true. In this case, I really do think they have.
And even if it's not just one person, even if two people own the house, husband and wife, or two sisters own the house, they can still do this. They both just have to sign everything, right?
Yes, everything has to be signed in front of a notary, and it has to be filed with the county records. If it's not filed, it's not valid.
Okay.
Some deeds, they're valid as soon as you sign them.
Now,
in this case, it has to be filed.
It can be revoked. You can go in and change it. It's
Absolutely.
not permanent forever and ever. There is a way to change it.
You can change it. Now, like a will, if you don't think it needs to be good anymore, you just tear it up. However, with this, it says specifically you have to file a revocation with the county or file a new deed. So you can just do a new one with new beneficiaries.
Okay.
The most recent one will be the one that dictates.
And the reason for that is because it becomes a part of the chain of title.
That's exactly right. And that's critical, as you must know. Yeah.
So they can get all the forms online and do this. If they want to change the person that they're leaving their home to, they can certainly do a new form and change it. And for the person who is the beneficiary, when the person who owned the house dies and the beneficiary receives the property, what do they now have to do to make it official?
They have to file an affidavit of death for the person that's passed, as well as probably a copy of the death certificate.
Okay, so they need to file that with the county.
That's exactly right. And that puts them in the chain of title. Now they're the owner of the property.
And the reason they really need to do that is so that they could take out a home equity loan on it, or they could sell it. They really can't do anything with the property until they
exactly right.
do that.
Then they assume all the responsibility of the correct owner, which they now are. And they can have contingent beneficiaries too. So if something happens to your kids, it may go to your grandkids. It's whoever you list.
Okay.
It really is trying to satisfy your needs and your desires.
And it's really important, like you said, if the house floods or something, you want to be able to get the benefits of like flood insurance and
to mind your business, to take care of what you need to take care of, and you're the person doing it now.
So how would you find out? Let's say you're a child of an elderly person. How would you find out if something like this has been done, or is there a way to find out if this has been done?
Well, go to an attorney.
Or done correctly.
Go to an attorney. Come on, that's of course the answer. Okay, the reality is you can go to, in Harris County, we're lucky. We have a pretty good system. You can go there and do a search by name and see what's been transferred into the name of the person you're curious about.
Okay, so if your elderly parents said they did this, took care of it online, you could actually go and kind of double check and make sure it's all in order.
Exactly. Now, I really would recommend it. I've had people tell me many times, well, they said they were going to do this, well, they never did.
Right.
And then it becomes more complicated.
Yeah.
I mean, nobody plans to fail.
Yeah.
But we all know that they fail to plan, and that's what we don't want them to do.
Well, a lot of great information. I think this is really interesting that that the legislators came out with this. It's interesting how this all came about, and I do hope that more people learn about it. A lot of people, like you said, still don't have wills, and so this could be a huge benefit for them to transfer title. This is the Texas Transfer on Death Deed, and it was enacted, or it became effective September of 2015. And to be effective, to make this deed effective, it must be in writing, contain the legal description of the property, include the name and address of the designated beneficiary or beneficiaries. It can be more than one.
Yes, it can.
And must be signed by the grantor, which is the property owner, in the presence of a notary. So just get it filed at the courthouse if that's what you need to do. And if you have any questions, certainly they can give you a call.
They can.
Christopher Barber, attorney and counselor at law for the Houston Law Group. Give us your website again in case someone wants to pull these documents and read more about it.
Sure. It's estateplanninginTexas.com, and my phone number is 281-464-LAWS.
All right, estateplanninginTexas.com. We'll be right back here on Houston Real Estate Radio. If you missed any of today's show, catch us online at HoustonRealEstateRadio.com.